Sir, you were charged with evading arrest or detention. On that case, you're facing up to a year in jail and or a $4,000 fine. You're also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A, so you're also facing a year and or a $4,000 fine on those cases as well. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy, with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID. And that's it, Your Honor.
Today, we're looking at a case involving a young adult whose sense of entitlement has pushed him far beyond common sense. At just 21 years old, his interactions with the justice system are already extensive, showing a repeated pattern of reckless choices. Instead of learning from earlier warnings, he continued down a path that only led to deeper trouble. For a while, he treated serious situations as if they had no weight, moving from one incident to the next without hesitation. Real life, however, does not offer restarts or do-overs. Every decision adds another layer to the record, and those layers eventually become impossible to ignore. He seemed convinced that consequences would never catch up to him, believing he could operate without limits or accountability. This kind of confidence is often seen in young offenders who mistake silence for approval and luck for immunity. But ignoring reality doesn't make it disappear. Now, that false sense of control is meeting the structure of the courtroom. This is the place where actions are examined closely and excuses lose their power. What once felt like freedom is now turning into responsibility, and the results may change his future permanently.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you, and all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here, a Kendrick Rashard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024 did then and there unlawfully while in the course of committing a theft of property owned by yada 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 with intent to obtain and maintain control, intentionally and knowingly caused bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweeney stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle the day after our two cases. I guess that's how they caught up to him, right?
They must have him. They found him, and that's when they arrested him on that, and then got picked up on me, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he?
Yes, Judge. It says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
This defendant presents a serious danger to the public, and the idea that he has been allowed to move freely is deeply disturbing. He has repeatedly shown that he cannot be trusted to exist responsibly in everyday society. Driving, walking freely, and interacting with ordinary people going about their lives are privileges he has clearly abused. The acts involved here are not minor or misunderstood behavior. We're talking about extreme violence, brutal physical attacks carried out with complete disregard for human life. Causing someone to fear they may not survive an encounter is not immaturity. It's a complete rejection of consequence and basic humanity. The fact that such conduct resulted in release instead of immediate restraint raises serious concern. Even after being given another chance, he wasted it almost instantly. Instead of stepping back or correcting course, he returned to criminal behavior, engaging in theft, fleeing law enforcement, and acting as though real life were a stage spectacle. This is precisely the type of individual judges refer to when they speak about the need to protect the public from ongoing harm. His actions reflect a consistent pattern. No concern for others, no acknowledgement of harm caused, and no acceptance of responsibility. Each time the system shows restraint, he responds by pushing even further, escalating his behavior with alarming confidence. This isn't a one-time lapse in judgment. It's a repeated cycle that leads toward only two outcomes. What stands out most is his demeanor in court. The dismissive posture, the lack of seriousness, and the apparent annoyance at being held accountable are glaring warning signs. Judges recognize that expression instantly. It signals someone unlikely to change without firm intervention. At this stage, the courtroom no longer feels like a consequence. It feels like familiar territory.
I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to meet with me today, promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high. I'm going to set them at $20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
you, Judge.
I don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is an absolute, just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but and I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today, promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
So I guess the felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond news with Felicia, and then after that, just pretty good. Okay.
Wait, excuse?
Yes, ma'am. And thank you for everything.
It's hard to believe someone so young could already leave this level of damage in their wake. At 21 years old, most people are focused on work, education, or laying the groundwork for their future. They're trying to move forward, not stacking serious charges as if it were some kind of race. The real question is whether this path can still be changed. Is there a moment where reality finally sets in, or will the cycle just continue until the consequences become unavoidable? Because one thing is clear, those massive bond amounts are not something he can simply walk past. The court made sure of that. For now, being held in custody may be the only chance he has to pause and reflect. While others his age are building lives, he's watching time pass from behind locked doors. The direction he's heading doesn't lead to excitement or freedom. It leads to narrow hallways, steel barriers, and an identity reduced to a case number. What drives this level of recklessness in young offenders? A complete lack of fear, no concern for the harm caused, and a willingness to destroy everything in their path. But there comes a point where society has to draw a firm line and stop absorbing the damage. So what do you think? Could this be the moment that changes everything? Or are we looking at the setup for another courtroom appearance in the near future? Share your thoughts below. Thanks for watching. Make sure to like and subscribe, and I'll see you in the next one.